Ladies and gentlemen, welcome aboard the Wright Flyer. As always, this is your captain, Randy Wright speaking, and I'd like to take this opportunity to personally thank each and every one of you for choosing to fly over the friendly airwaves with us here at our state-of-the-art radio program, Radio Aviation Excellence, the Wright Flyer. Now, ladies and gentlemen, without any further ado, let's go ahead and delve into the topic du jour, which I have selected for today's episode of the Wright Flyer. It's an important one. It's one that is covering something that I haven't seen in my years of practice, and I've been at it now for a decade coming this November. One of the things that's happened is there's apparently been a leak, and it's been confirmed by the Chief Justice, John Roberts, as being an actual opinion that was to be handed down by the highest court in the land during this session, and it's one that would be overturning a major portion of Roe v. Wade. Of course, Roe v. Wade was that decision that was handed down by the Supreme Court all the way back in 1973, which sought to make abortion legal. And it did so through the notion that was initially established sometime earlier in the prima facie case, or the groundwater case of Griswold v. Connecticut, which involved contraception. At the time, Griswold stated that it was illegal to have contraception, and the Supreme Court had delved into an area of constitutional law that was not found within the clear and concise language contained within the four corners of the Constitution, using the notion of substantive due process. Due process has two types. There's procedural due process, which is your notice in a hearing and the ability to face your accuser or whoever is bringing a legal cause of action against you. And then substantive due process is a murkier one that was ripe for abuse, and one which the left wing, particularly within the courts, used to expand the bounds of judicial fiat. We saw this with the gradual expansion to include gay marriage. We saw it with the way that they expanded health care. It was activism in a way that had never really been exposed or utilized to quite such a degree as it was in 1973 with Roe v. Wade, and then as it was further solidified with Planned Parenthood v. Casey. We know that Alito was the Associate Supreme Court Justice that had authored the opinion in question. We know that it would strike down the viability portion of the original Roe v. Wade decision, and this is something that the left was afraid of. But does it really change things as drastically as the fearmongers in Pavlov's School of Journalism for the salivating mainstream media or legacy media would have us believe? No. It would merely hand it back down to the states who have already, with the changing standards of medical science, begun to walk back the notion of a substantial burden or an unreasonable burden on a woman's access to abortion. It literally was, going back nearly 50 years ago, and 50 plus years ago with respect to Griswold, a gross expansion of the Supreme Court's power and authority. It was legislating from the bench, for want of a better term. And what it tells us is that the court had created a constitutional issue, a constitutional crisis that could have been avoided if the courts had simply done their job and allowed the legislature to handle this and to allow it to be a state issue as it had been. But the court was, at that time, going through a drastic shift, a diametric shift from the type of role that it had. This, of course, dates back to the type of assaults that the court had undergone with FDR's court packing scheme and later with the Warren Court. So these things had a change. But we can see with the initiation under the Griswold decision, it went from this substantive due process right to privacy, expanding to what they now blatantly refer to as a woman's right to abortion. But again, that's not something that is found within the confines of the Bill of Rights or first 10 amendments to the United States Constitution. That is something that the courts had pulled out of thin air. It was a right that they concocted themselves. And again, with the substantive due process clause within the 14th Amendment, they had started something that would be an unraveling chain of power, or a power grab, for want of a better term, much in the same way that they used the Commerce Clause to claim enumerated powers that the Founding Fathers would have never intended to be within the auspices of the federal government. So it allowed government to become much broader in its scope and expansion, as well as its application, again, in ways that would have hitherto been impermissible. And we see that the notion was this idea of it being an unreasonable burden on a woman's access. And where that went is basically they said anything that would prohibit abortion prior to the third trimester would be an unreasonable prohibition on a woman's right to choose. That's how they framed it. That's not how it really is, and we can see that with the unreasonable burden standard being whittled away as the viability of the fetus, which was the topic of conversation in Roe v. Wade, when they struck down Texas's abortion law at the time, what was that if the fetus could not survive on its own at that stage, then the notion of life at beginning at contraception no longer applied. At least that was how it was framed, that was how it was argued, and that is the sort of mentality that was latched onto by the proponents for abortion. Now, initially, they had argued that the idea was that they wanted it to be rare but available. But it's not that. And we can see that preemies, or children that are born early, have a much greater chance of survival now than they did 49 years ago. Therefore, it was really only a matter of time before this would be revisited by the courts. After all, several states have begun enacting new legislation to be more in line with the discoveries and advancements that have been made in medical science and medical abilities since 1973, when Roe v. Wade was handed down. We know that a lot has changed in the 49 years since Roe v. Wade was handed down. And so, even from the mindset that the court had at the time of Roe v. Wade, it is proper for the court to review this and to put it in the context of the Constitution as it should be, and as it always should have been, but hasn't necessarily been that way. Needless to say, this notion of a leaked opinion, that is very rare. Usually the Supreme Court is run like a tight ship. There is a lot of secrecy. There is a lot of formality that exists within the confines of the highest court in the land. So for there to be a leak is unusual. But it shows the politicized nature of just exactly what it is that we're facing, and the goal of what the frothing at the mouth Fabian socialist leftists are hoping to achieve here, which is namely to apply political pressure. They want to force justices to change their minds. They want there to be that type of political tension, that political derision and division that we saw, such as during the Summer of Love of 2020. They want a proverbial fire, and in some cases, perhaps even a literal fire, to erupt in the political heartland of the land of the free and the home of the brave. And again, rare but available is no longer their position. They want partial birth abortion. It wouldn't even surprise me if they wanted post-birth abortion, so long as it was of a class of people or a type of people or an insular, discrete group of people that they disagree with. Look at the way that they have basically turned to identity politics each and every time to double down on their initiative, to push forth in something that is heinous and ugly. That is what their end goal has been. And it's readily apparent, it's grotesquely apparent that this is what they're doing. And at the end of the day, it shows that their goal and that their initiative and that their modus operandi is not one that is in line with the American people. It's not in line with what the vast majority of the people want. They want more restrictions because it really doesn't make sense. This type of mindset that these rabid leftists are pushing for. And so it goes to reason that this challenge has arisen. Of course, reason is something that doesn't really factor into the left's political agenda. We saw that, again, pointing back to the Summer of Love of 2020, when all of the violence, all of the chaos, all of the carnage of that time was put on full display in our major metropolitan areas. Thus, the motives for the leak are what come to my mind now. That is the question that just is simmering in the back of my mind. Why? Why now? Why would they leak it? Well, it goes to something that Crowder said, and I think he had it right, that they are looking to exert pressure on the justices, much like they had attempted to do during the Obergefell decision, which was Obamacare. Remember how that seemed to go contrary to how accepted wisdom, traditional wisdom on the court, predicted that it would have? Of course. It felt like there was pressure being exerted. And again, the weak link in all of this is Chief Justice John Roberts. Again, putting on full display the jurisprudential allegiances that he has, the viewpoints that he has, that are not strictly textualist or constitutionalist. That is par for the course now. And it's been this evolutionary shift. He has been always looking out towards public pressure, something that the courts and the judiciary, by its very design, is not supposed to do. There is a reason why it is so different and so detached from the political processes that it's supposed to be away from this, because of the lofty weight and nature of the court's role. And that is particularly true when it comes to issues of life and death, which abortion at its very nature is. That is what is at the heart of it. I think we are certainly at an interesting crossroads in the court's history. We are at a time where medical science has made it to where children are viable at a much earlier age. My nephew, for instance, was born almost 2 months early. At the time of Roe v. Wade, that would have been a disaster. It would have been much more likely that he would have not survived. But with the neonatal care that we have, the preemie care that we have, it is easier for them to survive, and it is easier for the question of life and death to rest at the heart of it again. So yes, it's being revisited, and yes, it would appear that reason is being applied. But just because this is being handed down, it does not mean that abortion per se has been made illegal, like the alarmists in the media would have us believe. Reason, once again, must come to the surface. It must be what governs here. But that does not appear to be what is going to happen. So fasten your seatbelts, folks. There's going to be a lot of turbulence riding through the country. With that said, ladies and gentlemen, I once again want to take this opportunity to thank you for tuning into the program. I look forward to seeing you again the next time we fly over the friendly airwaves. Please do take care. See you around.